In this video, I want to explore the importance of international trademark registration for US brand owners. I want them to learn when it's necessary and discover the strategies for protecting your brand globally. Let's start with talking about registering your trademarks internationally. Trademark protection is jurisdiction specific. A common law trademark only protects the mark in the geographic area of use. Although it's harder to enforce, it is the lowest level of trademark protection afforded to a brand owner. Similarly, a state trademark registration only protects that mark in the applied state. Federal trademark registration at the United States Patent and Trademark Office is the holy grail for trademark owners when protecting their brand in the United States. However, if you have a brand that will touch international markets, getting your trademark registered and your brand protected as a business owner is critical. International registration should extend to every jurisdiction that you intend to offer the products and services associated with your brand. Unlike the USPTO, most countries do not require the use of the trademark before registration, although there are similarities in the international registration process. To protect a company's brand internationally, it is advised to consult a trademark attorney familiar with the process. You might ask, how can I apply for an international trademark? To successfully register and protect a trademark internationally, it is crucial, as I mentioned above, to consider the specific geographic regions where enforcement will be necessary. Rather than immediately pursuing an international trademark registration process that is going to be labor intensive, it is advisable to consult with a trademark attorney who can provide the guidance on the most effective strategy for expanding your brand's enforcement efforts. Now you might ask, how do I need to apply in each individual country? Or can an applicant's trademark registration cover more than one jurisdiction? Simply put, yes. The international trademark registration system is, like I said, jurisdiction specific. So registering your trademark internationally requires understanding the different trademark application systems available. A trademark applicant filing at the European Union Trademark, or EUTM, for registration will protect your brand in all EU member countries. The Madrid system, governed by the Madrid Agreement, established a protocol allowing international trademark registrations in many countries. Similarly, registration at the African Regional Intellectual Property Organization, also known as ARIPO, gives trademark rights in English-speaking African member countries. Whereas the African Intellectual Property Organization, or OAPI, based out of Cameroon and formed by members of French-speaking African countries, protects the trademarks in the member states of this organization alone. Now, international trademark registration doesn't just have to be these major organizations. It can be through individual countries as well. Organizations such as the World Intellectual Property Organization, WIPO, or the EUTM, the European Union Trademark, offer international application systems that provide trademark protection in numerous countries. However, the drawback of this approach is that the national trademark offices will use your trademark application, or basic application, or registration, basic registration, in your home country as a basis for filing for examination. Hiring a local counsel to file for trademark owners seeking to have their nation-specific trademark application examination insulated can be beneficial. Hiring an international counsel for your brand's protection can seem daunting, but if you work with Rishi Law for your international trademark registration needs, we have relationships with and can recommend you to local trademark law firms and attorneys worldwide. I want to take this time to delve a little bit more into the Madrid Protocol, the international registration system. The Madrid system is an international trademark system that offers trademark protection in up to 130 countries. The system is administered by the World Intellectual Property Organization, WIPO, based in Geneva, Switzerland. A list of the members of the Madrid Union contracting to the Madrid Protocol can be found on the WIPO website. The advantages of the Madrid system include not having to hire multiple local attorneys for registration in national trademark offices. Additionally, it is a centralized system that provides a cost-effective solution for international brand recognition and enforcement. Another advantage is if a trademark registration is used as the basis for international registration, the examination process is more controlled and shorter when compared to the one at the USPTO. The Intellectual Property Office of each member country is given 12 or 18 months to grant or refuse the application. A disadvantage of the system, as mentioned above, is that the refusal, cancellation, or withdrawal of an application or registration in the home country will lead to the same result for international registration. This is the 5-year dependency period, where the international application and registration depend on the home country application or registration. I want to also take this time to give you a case example of international trademark enforcement. This is a case of Starbucks versus Sardar Baksh, a coffee chain in India, formerly known as Sardar Baksh and now operating as Sardar G. Baksh Coffee and Company, experienced a rapid success upon launch. However, Starbucks Corporation, a global coffee giant, as we all know, filed for a lawsuit for trademark infringement. This was due to Sardar Baksh's use of a similar name and logo that could potentially confuse customers. You can see on the video here the two logos and the names, and you can determine yourself if that would have been confusing to a consumer. In response, Sardar Baksh changed its name and adjusted its logo to avoid further issues. This highlights the significance of protecting intellectual property and being cautious when creating a new brand identity. While drawing inspiration from industry leaders is common, it is crucial to avoid crossing the line into trademark infringement. This case serves as both an example of trademark enforcement on an international level and a valuable lesson for trademark owner. If your brand needs international protection, or you're looking for answers regarding your brand protection and enforcement needs, please feel free to reach out by booking an appointment with Drishti Law by going to www.drishtilaw.com or call us at 773-234-1139. As always, this is Sahil Malhotra, and thank you for watching.